and part. Okay, really good for posterity. Uh, these things are not often noted, and I did some research and I found out that the NCAA, the National Collegiate Athletic Association, which was founded in 1910 by Theodore Roosevelt, who was a great proponent of women's suffrage, that's been a metaphorical thorn in the side of Title IX occasionally. Wendy says it's still going on. In 1976, they filed an unsuccessful lawsuit against the legality of Title IX, attempting to exempt revenue producing sports from the policy's authority. They were not successful. But even now, I hate on the 50th anniversary, I hate to tell you, in 2020,
You hand me that back.
even, can you hear me? Even now in 2022, 90% of colleges don't offer athletic opportunities to female athletes proportional to their enrollment. Terrible. But now I would like to introduce my friend. I'm very pleased to introduce my friend Jennifer Martin. Jennifer, with my glasses on, Jennifer is an assistant professor in the Department of Teacher Education at the University of Illinois in Springfield. Prior to working in higher education, Dr. Martin worked in public education for 17 years, 15 of those as the department chair of English at an urban alternative high school for students labeled at risk for school failure in metropolitan Detroit. She has been the editor of the Journal of Urban Learning, Teaching, and what is it, Jennifer? And Research. She just sent me the acronym. Since 2018, and has taken an active role in revitalizing the journal, as well as transforming it into an online and open access forum. She is the editor, and I love this, of Racial Battle Fatigue Insights from the Front Lines of Social Justice Advocacy. She is the 2019 recipient of the Paula Silver Case Award for her article, The Bathroom Case, Creating a Supportive School Environment for Transgender and Gender Nonconforming Students. In 2021, she was awarded the Brooks Oakley Distinguished Online Teaching Award. There's so much, she has so many accolades, I simply cannot tell you all. I wish I could. 38 pages of a resume, she told me. Wendy Murphy. We're so fortunate to have attorney Wendy Murphy. She received a bachelor's degree from Boston College in 1983, and no one graduated in 1983. That's just too short a time ago. And a Juris Doctor from New England Law in Boston. She began her career as a prosecutor in Middlesex County, handling child abuse and sex crime cases, and then moved into private practice, focusing on violence against women and children. She's an adjunct professor of sexual violence law at New England Law in Boston. And I love this, she was a visiting scholar at Harvard Law School from 2002 to 2003. Then she successfully sued both Princeton University and Harvard Law School for violating Title IX regulations by mishandling sexual assault complaints. Of the case against Harvard Law School, attorney Murphy writes, the case began when Harvard Law School hired me as a consultant in early 2010 in connection with the Title IX matter. When I pointed out to Harvard officials that their policies were non-compliant and they refused to fix them, I filed a complaint with the Office for Civil Rights in which I identified numerous substantive and procedural violations of Title IX that were then in place in the law school's policy. And my favorite, she has, I can't tell you how many publications, but I'll just mention two before they pull me out of here with a rake. This was one of her articles, How Title IX Won Its Rightful Seat at the Civil Rights Table of Justice and Why the Legs Are Still So Wobbly. And the second one I like, Sexual Harassment in Title IX. What's bullying got to do with it? And with that, I present these two wonderful warriors, Jennifer Martin and attorney Wendy Murphy.
Thank you so much, Jerry. That was lovely.
Thank you.
I'm going to share my screen in a moment, but I just want to tell a little quick story about how Wendy and I met. Wendy and I met through a mutual friend / mentor named Michelle Paludi, who is a very famous sexual harassment scholar. And so Wendy and I have presented at a conference on sexual harassment, and we've written things together, and I'm very honored to be here with her today and to call her a friend. And Wendy, since we are celebrating 50 years of Title IX, as I pull the slides up, can you share the quick story that you recently shared with me about what Bernice Sandler calls you and the background of that?
Well, thank you so much, Jennifer. And I'm really blessed and so privileged to work with Jennifer and to call her a friend. Title IX, my work in Title IX dates back to when I first found out that Title IX didn't only apply to sports, which was, I think, 1993. I've been a Title IX activist ever since. In connection with that, I had a chance to work with Bunny Sandler, who many of you may know, on a really important case that we may or may not get to. But in connection with that, and we worked really hard on this case, and I got to know her, and I just adored her. But anyway, I of course called her, because that was her name at the time, the godmother of Title IX, and she just dubbed me, which I take to be such a wonderful honor, the goddaughter of Title IX. So I'm going to take it, even if no one agrees. Bunny said so.
There you go.
I agree, Wendy. I think it's fantastic. So should we get started?
Yes.
All right, great. So when Jerry asked me to do a little talk on Title IX for you, I thought I need to bring in my friend Wendy, because she is, who knows more than she? No one. Okay, so let's go. This is a little about Wendy.
Oh my God.
So Jerry has given a great introduction, but there is just so much more. And I'm going to share a link in the chat a little bit later today so you can have it. But I have a podcast, and Wendy and I, it's two parts. Wendy and I talked for about 90 minutes about the ERA. So there's just so much that Wendy has done. If you're interested, she has a book called Injustice for Some. She's won a lot of landmark cases. I didn't know that some of the cases led to the 2011 Dear Colleague letter, which I'm going to share later on. And I want to hear more about the Betsy DeVos situation. And you can see her. I've turned on the news several times, and I see her face. She's a legal analyst for CBS, NBC, CNN, and Fox. She's also a fan of hot yoga. I am not. I'm a fan of yoga, but that's too hot for me. And a little about me. Jerry already said, I have nothing else to add except for my two little dogs here, Mimi and Malcolm. And I'm going to share this link to my podcast later on. All right, so today we are going to just give you some content and information on Title IX, not in Title IX, oops, mistake. And Wendy's going to give some updates as to what is going on now. And it's not all good news, unfortunately. Then I'm going to ask Wendy some questions, and then we'll open up questions to the general audience. But let me just say, if you need clarification on anything that we're talking about, please put it in the chat, and we'll get to it as soon as we can. So Wendy, do you want to talk about this timeline?
Boy, we could spend the entire time unpacking this timeline. What I want to propose is that people take their own time to look at this and ask questions, not necessarily today. If you have any, if you're interested in more detail, what I think I should say, just to quickly explain this timeline, is to emphasize the subheading here. We went from equality to sports equity to subjugation. That's where we are now. And that's what I think is so troubling about the evolution of Title IX. When Title IX was first enacted, it was in 1972, in response to the civil rights movement. Women, by the way, were part of the civil rights movement. We like to separate the women's movement from the civil rights movement, but actually women's rights are civil rights, so I don't do that. But the point is that the ERA was passed by Congress within months of Title IX being enacted by Congress. And there was a reason for that. Women were demanding full equality. We didn't have any equality at all. We didn't even have basic citizenship rights until 1971. We were not even considered persons under the 14th Amendment until 1971. So we were fighting for what we think of as the most fundamental and basic rights at this time. And we got the ERA passed Congress, and we got Title IX at roughly the same time. What's important to remember, I think, is that the ERA then, of course, had to be ratified by 3/4 of the states to become part of the Constitution. So while that was sent off in 1972, sent off to the states to be ratified, we were given the equivalent of the ERA in the special environment of education. So Title IX was like a mini ERA that applied only to education, while we waited around for the ERA to give us equality everywhere. And I don't think a lot of people understand that, the relationship between ERA and Title IX. Yeah, and then the other kind of horrible parts of the later aspects of this slide explain, and I'll just boil it down, explain the important issue, which is, for me, which is that Title IX was never about sports. If you read it, it speaks to equality in admissions, equality in programs and activities, and equality and anti-discrimination under, basically in any aspect of education, right? So you have to admit women equally, you have to treat them equally, and you can't discriminate against them. Like, this was a real holistic, full picture protection for women in all aspects of education. And yet Title IX, in its immediate aftermath, was propagandized as a sports equity law, in my view, to intentionally deprive women of the knowledge that Title IX was in fact a very broad civil rights law that had very little to do with sports. When I was in school, I assumed Title IX had nothing to do with me because I wasn't athletic. And when I discovered it as a lawyer, as a young lawyer, when I read it, I thought, what? I was ripped off with the lack of knowledge. I should have known about this sooner. Not only is this a civil rights law, it applies to sexual assault and sexual harassment as an even broader category, right? That includes things that are offensive, but not necessarily assaultive. And how did I not know this? So that was in 1993, and I started pushing for more public understanding of Title IX's relationship to sexual assault. That's a big part of my work. But this slide explains the sad thing I want to share with you is that as soon as women started demanding that Title IX be applied to sex-based harms, such as sexual assault, dating abuse, stalking, all these things that were happening at very high rates on campuses, is when the fight began to weaken Title IX. And where we are today, sadly, is, I think, at the opposite end of where we started. Title IX started as a guarantee of full equality and full and equal protection against sex discrimination. And because women started demanding that it have that broad-based civil rights application, it has been weakened, especially clearly in the 2020 regulations that were promulgated by Betsy DeVos. So we can talk about more of what those problems look like afterwards, but I just want to let you know that we started off with equality, went weirdly down to sports, and then once we figured out that we were not being treated correctly, that Title IX was actually quite a bit broader than that, Title IX was substantively weakened, and that's where we are now.
Right, thank you. And I will share these slides with Sally so that you'll have access to this slide later. And I'll just impart that I feel like I speak on campuses and to students and other professors, and the idea is, if everybody could please mute themselves, that would be great. I'm hearing some crosstalk, unintentional, I know. But anyway, there's still the misconception, and it is rampant that Title IX just has to do with sports. So we're first going to talk about, or Wendy is, the new Title IX regulations. And what can we do?
Yeah. So here, oh, sorry,
Sorry.
go ahead, Jennifer.
No, go ahead, Wendy.
So for those of you who may not be familiar with the simplicity of Title IX and its simple language, I should say, here are the three categories of broad protection that women won in 1972. And in a nutshell, you cannot be denied access, right? So you have to be equally admitted to participate in education. You cannot be denied benefits when you're in the world of education, any aspect of it at all. And you cannot be subjected to discrimination under. To me, number three is really the place where we should have spent all of our energy, because what does that mean, subjected to discrimination under? And how does that apply to things like sex-based harm, sexual assault? It isn't just about not being paid equally, although academic women are often still today paid less than men for the same quality of work. But what forms of discrimination are being protected? One thing that I want to emphasize, and I guess I'm going to go a little bit backward to the basics, is that when women were fighting for Title IX in the late 60s and early 70s, we weren't fighting for Title IX at all. We weren't asking for Title IX. We were simply asking for Title VI to be amended to add sex as a category. Most of you probably don't even know what Title VI is. Most people don't. Title VI is the exact same kind of civil rights law enacted by Congress, but this back in 1964. But it excluded women, and it has exactly the same language. No person in the United States shall, on the basis of sex, be excluded from participating. I'm sorry, on the basis of race and national origin, be excluded, denied, subjected to discrimination. So that's what Title VI says, right? It applied, it had the same broad scope. It applied actually even beyond education, but it was about civil rights and protection against harm, and it applied to education. So women said, when they were fighting for what we now know of as Title IX, women said, we don't want Title IX. We want to be added to Title VI. Just open up Title VI and add after race, color, and national origin, comma, sex. That's all. Very simple add, right? There was enormous hostility to that idea. The lead opponents to that idea were higher ed, in particular, Harvard, Yale, some of the elite schools led by the Ivies. They fought fiercely and lobbied heavily against adding women to Title VI. And we won the consolation prize of Title IX as a segregated, separate that
Oh, for
applied,
heaven's sakes.
separate statute that applies only to sex. And that was the beginning of the problem. This notion that women should be treated differently when they suffer harm based on sex than people who were suffering harm based on race or national origin. That was the beginning of the problem. And that was the beginning of an era where being able to mischaracterize Title IX as something that applied to sports, they were able to get away with that because we now had a segregationist statute rather than just becoming part of Title VI. And had we just been added to Title VI, it would have been very difficult to mischaracterize Title IX as a sports-only statute.
Wendy, I have a quick question for you, but before I get to that, Sally, you should have
Yes.
muting privileges.
Yeah, where
Can
is
you make
that?
sure everybody is on mute?
Yeah, can we do that? Can I just mute everybody, then unmute you too? How's that work?
I can unmute myself, but if you mute, well, if everybody could mute themselves,
Yeah.
we're getting some sound in the background.
Yeah, Carolyn Blackmore just came in, and I think she doesn't realize she's not muted. Let me see. It looks to me like everybody is muted. Now, hold on a minute. But yes, we definitely need that here. Oh, here's another one here.
All right, as you do that, I'm going to ask Wendy a question. Wendy, do you have an idea, or can you clarify for us why the Ivies would be so resistant to adding sex into Title VI? What did they have to gain there?
Well, the short answer is the Ivies in particular were very hostile to the concept of women being equal. They were, institutionally speaking, a source of oppression for women. They didn't let women in for a long time. To the extent they started to let women in, they wanted to be able to keep the numbers low. So when they went to Congress to lobby against adding sex to Title VI, one of the compromises they proposed was to add a caveat, add an exception that would allow them to accept only 30% of women. In other words, they didn't have to have equal access to education. They could allow no more than 30%. They could get away with accepting no more than 30%. So they wanted permission to discriminate under the power of a law that was supposed to prohibit discrimination. And frankly, they had the authority to ask for that because women didn't yet have equality under the Constitution. You can pass a law in Congress and in many states, you can pass a law that explicitly discriminates against women because women still today are not entitled to equal protection of the laws. And so long as we don't have equal protection, it's acceptable to lobby for women to be treated as second-class people. So they were, in a sense, just taking advantage of the fact that the Constitution still did not protect women equally. If you ask me, was there a more malevolence to their agenda? I think the answer is yes. They know, the Ivies know, the elite schools know that if we adopt a rule of law in an institutional environment like higher education that treats women differently and worse than other categories of people, then we are training young people, training their minds to conceive of women as other, as different, as worse, as lesser. Mm-hmm. And I do think that was intentional, just sort of as part of the public design. Let's perpetuate the status quo, perpetuate hegemonic ways of thinking about women and social structures and hierarchies. Yeah, I mean, I'm not sure they would call it malicious, but I feel that it was malicious because perpetuating that hierarchy is obviously very harmful to women.
Right, I would agree. And this is why the ERA is so important, which we'll get to. And for those of you that don't know, and correct me if I'm wrong, Wendy, Bernice Sandler, the godmother of Title IX, started in this quest because she was unable to secure employment in higher education as a professor. That's right, Wendy?
Yes, yeah. The initial impetus for Title IX, what we now know of as Title IX, although Bunny also wanted just to add sex to Title VI, the initial impetus came from academic women who were not being hired. They weren't perceiving at that time that this would be a broad-based civil rights law that applied to other areas of women's lives. But of course, that is what civil rights laws did. And we know, for example, that when Title VI was enacted in 1964, that of course it would apply to things like race-based assaults. I mean, we sent little Black children to school, to white schools with armed guards beside them because we knew that they faced race-based physical harm, right? So conceptually, we should have understood Title IX was similarly designed to protect women from sex-based harm, like sexual assaults and other forms of sex-based harm. But because it was segregated out as a different law than Title VI, it was then treated as different and worse. And it was used differently. The language of civil rights wasn't attached to it. And to this day, you will find people who don't think that Title IX is a civil rights law because we have used the propaganda and our language to frame it differently and therefore treat it differently.
Right, thank you. So let's talk about the 1975 regulations.
Yeah, these are so important and very few people even know about them, much less understand the importance of them. So Title IX as a statute, for those of you who don't know, laws come in their own hierarchical sense. Laws come in a sense of order, with the dominant and most powerful law being the Constitution, under that statutes, under that regulations, under that guidance documents that give us advice about the meaning of laws, right? So there's this hierarchy. Well, when a statute is enacted, like Title IX or like Title VI, it also creates in an agency, in this case, the Department of Education or the Department of Justice, the power to issue regulations to further the language of the statute. So statutes are written very small and narrow, but regulations can often be very voluminous. And those regulations are meant to give value to the statute. So the Title IX statute, which we've just looked at, guarantees equality in education and protection against discrimination, right? So when the Department of Education issued regulations in furtherance of Title IX, which was only a couple of years later, and it does take a little bit of time, a couple of years to issue regulations, those regulations were considered to be promulgated under, meaning subject to the authority of the statute, which requires equality. And we got in those 1975 regulations this wonderful language. Schools must adopt and publish grievance procedures providing for prompt and equitable resolution of student complaints. The investigations regarding complaints must be impartial, adequate, reliable. This is powerful language. And then my most favorite part of the 1975 regulations at the bottom of the slide is that students cannot be subject to different or separate treatment based on sex. The subject to different and separate treatment had exceptions. For example, separate treatment in bathrooms was permitted. Separate and different treatment in sports was permitted, but otherwise separate and different treatment was prohibited. So these were ways that the regulatory system was giving meaning to that guarantee of equality that was in the statute. These were brilliant. They were almost never used, but these are just as powerful as the laws themselves. And yet students didn't really understand that they even had a right to grievance procedures. So if they did suffer sex-based harm on campus, unless it was related to sports, because of the propagandizing of Title IX as a sports equity law, students didn't even know they had a right to grieve, a right to equitable treatment.
Right.
Students didn't know that it was illegal to subject them, girls and women, to different or separate treatment on campus. So these regulations were effectively not utilized and were in a sense invisibilized, I'll make that word up myself, by the propaganda around Title IX as a sports equity law.
Yes, I love the word, I agree. A couple questions. How did the feds, or didn't they, how do schools get this information? And was it intentionally not disseminated? And then I want to ask also about Title IX coordinators. So those of you who may not know, every school district has a Title IX coordinator. And when did that become enacted? The requirement of a Title IX coordinator, which is problematic in its own way. And I can speak to that in a moment.
Yeah, the mandate of a Title IX coordinator has also been around forever. And these regulations, though they are mandatory, were simply ignored by schools. And the reason they were ignored is because no one held them accountable. So it's sort of like if you make something mandatory, you say to schools, you must do this, because schools absolutely knew about these regulations. But if you then don't teach people that they have rights, then it's sort of, ships passing in the night. These are rights that exist, but only in the ether. No one's asserting them because they don't know they have them. Why? Because we only think of Title IX as a sports equity law. And by the way, I think there was a rather concerted effort to prop up the idea of Title IX as a sports equity law that came from, in part, a legitimate concern. The NCAA was certainly involved in this, a legitimate concern on their part that they were going to lose funding, that they were going to lose profits, that there would be a huge financial loss with regard to the money that comes from men's sports. Mm-hmm. So they did, in one sense, have a legitimate concern, even though I don't want to use the word legitimate, but it was sincere in the sense that they were driven by profits to not let Title IX undermine their financial interests. Mm. But it was the extent to which that was then propped up as the thing that Title IX applied to and covered. So it was like it served the dual purposes of giving people who cared about men's sports a huge opportunity to fight for regulations around the sports question that continued to protect them. And we can talk about that if you want, but it's similar. It simultaneously, inhibited women from understanding the breadth of Title IX as a civil rights law. What I will say about the sports thing is they have their own enormous body of law enormous kind of complicated regulatory scheme that explains what it means to require a school to provide equal distribution of resources for women's sports. The short story is that word equal doesn't actually mean equal because of how the regulations have been construed over the years to actually allow schools to do things with women's sports that tolerate and accommodate the seeming guarantee of equal distribution of sports resources, but they don't actually have to do what you think of as equal distribution. And then again, the only reason they can get away with treating the word equal as meaning something less than equal is that we don't have sex equality in the Constitution. When you don't have sex equality rooted in the Constitution, you can go to court and say that I have a law that says I'm entitled to equality under Title IX, equal pay, and the court is allowed to say, and this happens to me in my work, the court is allowed to say back to you, well, the word equal doesn't actually mean equal because you don't have a foothold in the Constitution's guarantee of equal protection of the laws. So I, as a judge, am allowed to construe the word equal to mean something other. That's where we are. And it's been that way for a long time. So that's where this kind of unequal treatment of sports began, and it continues to this day. And it's unequal treatment of sex-based harm, such as sexual assault, which continues today.
Right. And I will say one thing about Title IX coordinators. So school districts, universities have an individual, typically they have other job duties.
Way.
They're appointed a Title IX coordinator. But in my research, I have found that, and Wendy, please weigh in if on your thoughts on this, but in my research, I have found that these individuals are typically there to protect the institution and not the individual. So a lot of times they are in administrative positions, HR, human resources. They might be the superintendent or in the business office and not be in a position where they're close to parents and students in terms of being able to advocate for them. And a lot of times this information, it's supposed to be public. A lot of times it's not made public, like on school district websites. And so people, like Wendy said, people don't know what their rights are. They don't know that they have these protections or this person to go to file a claim. So when you don't know, you don't know. Do you have anything to add to that about the coordinators, Wendy?
Yeah, one quick thing about the coordinators is that most schools, which is, again, it's a problem with separateness, but most schools today do have coordinators, but it took forever to get them to obey this federal mandate that had been in place for decades. They finally have Title IX coordinators in place, but what's problematic, and it ties into what I've been saying, is they'll have a Title IX coordinator over here in this administrative location, but their organizer and or administrator for concerns under Title VI. So if you suffer race-based harm, you go to the Civil Rights Office. You go to the place that is framed, labeled, treated as a much more important office where civil rights are at stake. Women go down the office to the second-class treatment room where Title IX is seen as not a civil rights place, not a civil rights office. And so that it perpetuates and participates in that problem of seeing sex-based harm as segregated from, different from, worse than, not as important as all these other harms. So for me, when I think about women of color who suffer sexual assaults, for example, on college campuses, based on their race and their sex, and lots of women do suffer harm based on more than one category. Think about how they feel when they have to figure out where to go, who to report to. Am I going to go to the Civil Rights Office because part of my suffering was based on my race, or am I going to go down to the lowly Title IX office? The notion that they feel separated themselves is just so anathema to what we think about when we conceive of civil rights laws generally, and when we talk about the importance of recognizing people who suffer harm based on who they are. There oughtn't be a hierarchy within a single body, right? And so today what we have is students who are actually thinking to themselves, where am I going to get the best result? And they're often framing their suffering as something other so that they get a better result by going to that better office, the gold standard office. And I actually sometimes teach this to students. I'll say, if you can frame your suffering as based on race, national origin, whatever, do it. You don't want to, if you can get a better result, don't label it as sex-based. And I bite my knuckles when I teach people this, because that makes me part of the problem, that I'm participating in the erasure of women's sex-based suffering. But, on behalf of a client who wants a good result, it's a really sad place to be today.
How can we, is it possible to reframe Title IX as a civil rights law? How can we do this?
We can participate in the reframing with our own language and our own advocacy and the way we talk. Every single time someone suffers sex-based harm in connection with education, we have to do the framing. We have to correct people. We have to shame people who don't use that language of civil rights. We have to constantly, which I do anyway, every single thing I do on Twitter, I'm comparing and asking questions. Why would you suggest that this sex-based issue be treated differently and worse than this race-based issue? I'm not the only feminist who does this. It's been, done for years and years and years.
Mhm.
Feminists who do that constant comparison of race-based and sex-based suffering are doing an important service, because we are doing anti-hierarchical work, which we ought to be doing, right? And we're trying to, expose the hegemonic ways of thinking that hurt us. And this pecking order notion that some people are more important than others, it's so absurd. It's just absurd on its face. And collapsing that hierarchy is partly about language and the reframing thing that we can do. We don't have to submit to other people's framing. We can correct them. And it's easy. It's something you don't have to go to court to do, right? We all just have the power.
So audience, if you have one takeaway from today, it is to pass this on to your friends, your family, your colleagues, your coworkers. Reframe Title IX as a civil rights law. Talk back to the fact that it is more, right, exactly. It is more than just the sports law. So, and Wendy, I think you should get a whole bunch of new followers today. If you want to put your Twitter handle in the chat, that would be awesome. And then we're going to talk about these new regulations.
Yeah. Let me do my Twitter thing first. I can't do two things at once.
Yeah, of course. I'll just read a question that we have in the chat. If the ERA was finally passed, would this put women in the Constitution? The answer is yes. And we're going to get to that toward the end of our presentation. And Wendy's Twitter handle is @WMurphyLaw, and that is in the chat. We also have Leah asks, can you say something about the role of mandatory reporters on campuses?
Yeah, this is a pickle. Again, because higher ed has had total control on over the destruction of Title IX, but of course they can't appear to be destroying Title IX. So the current regulations are these boondoggle massive things that are partly meant to obfuscate so you don't see your suffering as clearly as you should. And one of the ways that the erasure of women's suffering is happening is through the recent changes in the regulations that enable certain types of people on campus not only not report, not count a report from a woman student about some sex-based harm. That was never the law until the more recent era. It used to be that any report of sex-based harm, wherever it happened on campus, had to be counted, had to be redressed. You didn't have to have the difference between formal and informal reporting. I mean, the problem that we have now is that we now have explicit regulatory support for the idea that a woman can suffer horrendous sex-based harm on campus. It can be known to a campus official, and unless that campus official wears a certain hat, it doesn't have to be reported. It doesn't have to be counted. So that to make up for that, and that bothers me. Now, mind you, a little part of my brain says, well, if the victim herself wants it only to be handled in a confidential setting, maybe that's good for her. I don't really, I'm not going to debate that, because I know that's real for many victims. And it doesn't have to be about sexual assault. If you suffer sex-based harm and you choose not to make a big deal of it because you're worried about retaliation, part of me says, well, the hell with retaliation. Like if you fear retaliation and stay silent as a result, you're just rewarding the retaliator, right? You're rewarding the systems that's designed to silence you. But the other part of me is respectful of the fact that it's a real consequence. You can suffer terrible consequences for reporting. Jen can talk at length about that. Oh my God.
Mhm.
But the point is that secreting women's suffering is often done through the benevolent mechanism of, oh, these people are confidential sources. So if you go to a school counselor or somebody else that the school has labeled a confidential reporter, then or confidential employee, then that person doesn't have to report and it all stays quiet, it all stays secret. The only way around the erasure of these, because then we end up with false data, right? Then we end up with falsely low numbers. And that's important too, because then statistically, we're going to read research that says, oh, there's no more sexual assault on college campuses, even though the real reason the numbers are low is because no one's reporting, or they're reporting only in these confidential environments. And we don't want that either. So the real solution is to mandate, which is somewhat happening, mandate annual surveys on every campus. Problem. And by surveys, I mean, you don't measure incidence rates by whether a case was formally reported. You measure incidence rates by surveys that ask people whether they experienced any kind of harm that fits this definition. So I'm very happy about these concepts of surveys. The problem is surveys are now, in part, this could change. This could change a bit because Biden has recently talked about proposing amendments to the current regulations, and they haven't been announced yet, so I don't know exactly what those amendments will look like. But there is a lot of focus on these surveys. The problem is the current definitions that are used in the surveys grossly undercount the reality of these incidents because they don't capture the suffering women experienced under the right legal terms. They use the kinds of legal definitions that most women would respond to by saying, oh, that didn't happen to me. And I'll give you an example, and I know Jen knows this. This study is probably at least 20 years old, but it speaks to the point, which is in this study, 75% of college students surveyed said they had never been raped. But when asked, have you ever been forced to have sex against your will, 75% said yes. The same number said yes. So definitions matter. You can under and over capture reality, and the survey opportunity is so important, but the language we used when defining what it is that we're asking women to report about is vital. And the current surveys that are mandated don't capture, not even close do they capture the kinds of incidents that women suffer that are very harmful to them. So for me, the solution is to do our own surveys. Like, don't let the government tell us how to define an incident that's worthy of surveying. Let's do our own surveys. And that is something we can do. Just look carefully at the definitions that are used to measure incidence rates and change the definitions so that we get a more truthful result.
Right, that's really interesting. Leah, I hope that answers your question. If not, please ask another clarifying question in the chat. And now, do you want to dig into the new regulations?
Yeah, so there's so much to say about these regulations. They're very lengthy. The new regs that came out in August 2020 that everyone thinks about as the DeVos regs, let's be clear, these were heavily lobbied by higher ed and elite schools, Ivies in particular. This is not the result of Republicans. These were absolutely the product of a bipartisan anti-feminist effort, period. And they began, the regulations that we now have that we think of as caused by Trump and DeVos actually began under Obama. I'm not going to waste all your time explaining all of this. I'm just going to say that this effort to get to these horrible regulations we have now was a 10-year strategy, if you will, that began in 2011, right after the Dear Colleague letter came out, which was fantastic because the Dear Colleague letter made clear that all schools have to treat sex-based harm the same way they treat race-based harm. This was like a pronouncement of egalitarianism. It was wonderful. And this was under Obama.
I agree. And I'm going to share this letter after I stop the slides, but you can still access it, but it's been rescinded. So
yes.
Can you tell us, do you think Biden will reinstitute this letter or no?
No. And I say that, and this is, really the point that matters the most. I say that because we don't tend to think about the weakening of Title IX as a bipartisan effort, because we often are told that, Trump hates Title IX, Biden loves Title IX. In fact, the oppression of women has always been a bipartisan male entitlement. It's always been about bipartisan male supremacy, period. That's why both parties are opposed to the ERA. Both parties were opposed to opening Title VI to add sex. So I think the most important thing is to remember this is not a party issue, which is why Biden will do some things, but won't actually rescind the new regulations. He will tweak them, he won't fix them, and he certainly won't reinstate the Dear Colleague letter. The Dear Colleague letter, which, by the way, again, the story about the Dear Colleague letter is not well known. I've written a piece, I've shared it with Jen, that it's a long piece, but it explains the true story behind how we got to where we are. And I'm happy to share it with you if you want. Just send me an email. It takes a lot of time to explain, but the short story is when I had 2 cases filed in 2010, my first case was against Harvard in 2002. That was the first big case that connected the dots between Title IX and sexual assault. It was a really important case in many ways. But then Harvard Law School actually hired me in 2010 to work on a case. And I told them, you're violating Title IX. I don't care if you're paying me, I'm still going to file a complaint against you if you don't comply. And around the same time, I had a case against Princeton. And Princeton and Harvard were doing the same things wrong. There's an inter-Ivy consortium of schools that sort of work together to create the same crappy policies around women's suffering. And both cases that I filed against Harvard Law School and Princeton in the summer and early fall of 2010, I then sent to DC headquarters of the Office for Civil Rights at the Department of Education. And I said, these cases, which were both opened for investigation, which meant they were both doing things terribly wrong, right? So they're both under federal investigation, but I sent both of those cases to OCR headquarters in DC. And I got amicus letters of support from the National Center for Higher Education Risk Management, from the Clery Act people. They both agreed with me, but my letter said, please see these problems at Harvard and Princeton and understand these are systemic in higher education. Please issue some kind of global guidance so that all schools will obey the law. Because I don't want to go one school at a time. It'll be the year 3000 before we get all schools on board. Can you just issue some form of global guidance so that all schools will come into compliance? And they told me, yes, Wendy, we're going to do that. And I did that tactically because I knew Obama was from Harvard Law School. Half of his cabinet was from Harvard Law School. He was going to be reluctant to rule against Harvard Law School in my case. And so this was also my way of saying, take the heat off Harvard, take the heat off Princeton, get some global guidance in place, and no school becomes the battering boy, if you will. And that's exactly what they did. So in response to my cases against Harvard and Princeton in April 2011, Joe Biden went to the University of New Hampshire and announced the Dear Colleague letter, which was, I could have written it. I mean, it agreed with everything I said about what Harvard and Princeton were doing wrong at that time. They didn't say, oh, and we're doing this in response to Murphy's cases against Harvard and Princeton. So it did seem to come out of nowhere, but I knew where it was coming from, and that was okay. I loved the Dear Colleague letter.
This story is amazing, Wendy.
I know.
Okay, I'm trying to be mindful of time. Sally,
what I was going to say though, Jen, just to finalize, give me 2 sentences. Higher Ed hated the Dear Colleague letter, and their lobbyists went to Congress 2 weeks later after it came out, literally 2 weeks later, and filed a law to overturn it. That law was then challenged in federal court by me and Bunny Sandler. That's where I came to work with Bunny. We filed a lawsuit in federal court in DC to overturn the law that sought to overturn the Dear Colleague letter. And in response to that, higher ed went to the Department of Education and eventually got Betsy DeVos to issue the regulations that are in place now. The short story is the current regulations, which weaken Title IX, were designed to overturn the very excellent Dear Colleague letter. And it took them from 2011 to 2020 to get that done. So that's the short story.
Wow, this is fascinating. Okay.
Yeah, so these are some of the problematic key aspects of the regulations that are really bad. It redefines, remember when we talked about the regulations from 1975 that mandated equitable redress? Equitable meant that you have to treat women equitably. You have to treat the sex-based claim equitably. The regulations redefine the word equitable. You ready for this? Equitable now means, this is so embarrassing. Equitable now means that you have to treat the perpetrator exactly the same as the victim. That is not how it works when somebody commits a race-based offense. The perpetrator of a race-based offense is not entitled to equity. He might be entitled to some fairness and due process, but he's not entitled to equity. You don't treat the harm doer the same way you treat the victim. That's only a rule that now applies to women, only applies to sex-based harm. They also removed the pre-existing prohibition against different and separate treatment. So now it is legal to subject sex-based harm and sex generally to different and separate treatments, despite the fact that the Title IX statute forbids it. In other words, these regulations violate the statute. A law that says you must treat women equally now has regulations that say you must treat women unequally. That's where we are. That's these current regulations. My biggest concern is the last bullet point here, which is that the definition of an offense has changed. Before the regulations, a definition of an offense under Title IX was the same as a definition of an offense under Title VI. Unwelcome, offensive, and based on sex. That was an offense. That was enough to establish that an offense occurred. Unwelcome, offensive, and based on sex. That is today still the definition of an offense based on race. Unwelcome, offensive, and based on race. That is still the definition. However, the new regulations have changed, just for sex, have changed the definition to unwelcome, based on sex, severe, and pervasive, and so objectively offensive that it denies a person equal access to education. That's what you have to prove. So if it's unwelcome and based on sex and severe, that's not good enough. Also has to be pervasive, and that's not even good enough. And it has to also be so objectively offensive that it denies, not affects, not minimizes, but denies the victim access to education.
And do you know, that's wild.
Unprovable. It's
I was just going to say, has
unprovable.
anyone brought a case and won under this standard?
No, what schools do now, it's an unprovable standard. It really is. So what happens now, and this is again intentional and by design, when a woman reports a sex-based offense, she often will choose to have her matter resolved under a generic disciplinary code rather than under Title IX, because the offense definitions under generic disciplinary codes are easier to prove in many respects than the current definition of an offense under Title IX. So what does this do? It causes, again, the gross undercounting of civil rights offenses. It also inhibits schools' liability exposure, right? Because Because if you address a woman's claim under a generic disciplinary rule rather than under a civil rights law, you can almost never sue the school for doing it wrong, because they have insulation from liability for not doing discipline right. The only time schools have liability for not doing discipline right is when they punish someone and that person says, I was wrongly punished. They can't get sued for inadequately redressing an offense under their disciplinary code. They can be sued for violating Title IX, but now that the standard is unmeetable, their exposure in terms of liability is much more limited. Does that make sense?
Yeah.
They also give schools, this is an important one that was just on the prior slide, I should emphasize. In order to determine whether an offense occurred under the prior regulations and under existing precedent, and certainly this is also true under Title VI, you only had to show that it was more likely than not that the offense occurred and was based on sex or based on race or whatever. 51% proof, that's the standard for a civil rights claim. And that's an important standard. Why? Because it doesn't value anybody's word more than another. It's a true egalitarian standard. If one person is a little bit more credible than the other, that's it, right? You don't have to expel the guy, but you have to do something. You have to do something. Schools now have permission under the new regulations to apply a burden of proof that's much higher. If you could numericize, it would be around the 75% proof that schools have permission to use now. And what that does to benefit schools is it gives them the ability to say to the victim, we believe you, but not enough to do anything to him. That keeps their tuition dollars flowing, right? The victim keeps paying because they say, we believe you. So the victim feels good. Oh, they believe me, but not enough to punish him. So the perpetrator's dollars keep coming in as well. It's that space that schools love that gives them the ability to look like they're on everybody's side and they don't appear, to be hostile to women. It's really a horrendous rule to require the word of a woman to have to be this credible, because being credible isn't good enough. You have to be this credible. That is a way of valuing the word of a man substantially more than the word of a woman. And it is the most blatant expression of sexism, if you ask me. This declaration that the word of a credible woman isn't good enough. She has to be super credible. That's currently permitted under the new regulations. That was not permitted previously.
Okay. And what about these bullets?
Well, this is a really sad situation as well. It used to be that you could file a complaint with the Office for Civil Rights for any non-compliant act by a school. They have now changed that so that OCR won't really do anything unless you can show not only that the school violated Title IX, but that they were deliberately indifferent when they did so. That's an enormously different standard, a much, much higher standard that closes the door of accountability. That used to be the only place really that students could go, because lawsuits are incredibly difficult to win, but you could at least go to OCR, which costs nothing. It's supposed to be the regulatory oversight agency that makes sure compliance happens. Now it's so difficult because this proof of deliberate indifference is required that it's deterring victims from filing complaints with OCR. I'm still filing complaints with OCR, and I'm just framing things a little bit differently and working with these standards and complaining, frankly, about this standard. When I complain to OCR about Title IX problems, I'll say, and requiring deliberate indifference is discriminatory. You can't discriminate. You don't require proof of deliberate indifference when you handle cases based on other categories, right? So why would you require it just for sex when sex discrimination is illegal? I still make these arguments, but it's complicated. It's much more complicated now. Schools also used to have to take, this is a really important second bullet point, they used to have to take effective action in response to any report of sex-based harm under a knew or should have known standard. So you never had to have direct proof of actual knowledge that a particular school official knew. It was enough if they should have known. And now it's changed to actual knowledge. So if you can show that they were negligent in turning a blind eye to what they clearly knew about, that's not good enough anymore. And they don't have to do anything. So now what that means is they now have an incentive built into the rules to look away, because they have less trouble legally if they look
Right.
away, and they can't get in trouble for looking away. So that's a really important change. Yeah, that's the only one I would emphasize on this slide. Yeah, that's the bottom one on this slide is important. It used to be that OCR could impose financial penalties on non-compliant schools. They never did. You know, schools knew that there wasn't really going to be any financial penalty because no school has ever faced a financial penalty for violating Title IX.
Let's reiterate that really quick, Wendy. For those of you who don't know, no school has ever had their federal funds pulled for violating Title IX.
No.
Even though that's always been the potential sanction, it has been the threat of losing money that made schools comply, right? Schools always said, we have to do our best at complying because we might lose federal funding. Well, now they're not even afraid of losing federal funding because the new regulations have taken away OCR's ability to sanction them financially.
This is
You can't sue.
so disturbing.
You know, lawsuits are really hard. And now you can't even get a financial penalty from OCR. So schools have a huge incentive to do the wrong thing.
Just ignore it.
That's terrifying.
Mhm.
Yeah. Yeah, this is just, me reiterating what I keep saying. If the exact same offense happens to a woman, and the quality of evidence is the same, the school is going to treat it worse than if that exact same thing happened to a different student based on race, national origin, and so forth. This is the most profound harm, in my view, openly treating an entire class of people differently and worse because of who they are. This, to me, is the most profound harm that the new regulations require, not permit, require. So what are we teaching young people? We're teaching them that women are different, not as valuable, unworthy of equal treatment. And then they enter the real world with these ideas about women baked into their brains.
You know what I'd like to know from our audience when we get to the Q&A portion, how many of you know about this or knew about these changes and how impactful they would be negatively to women? Okay.
And
You want to say anything about this slide, Wendy?
Well, this is kind of what I've tried to say and what I keep trying to say when I file complaints or complaints against schools or complaints in schools. I mean, I keep saying you cannot obey these regulations. They violate the statute. Remember, regulations are only allowed if they are promulgated consistent with the statute that gave the agency the power to create the regulations, right? An agency can't just issue regulations. They can only issue regulations consistent with the authority of the statute that gave them the power to regulate. So if a statute passed by Congress says women must be treated equally, you can't then pass a regulation that says women must be treated unequally, right? This is a legal argument that I keep making over and over and over, and it just falls on deaf ears. I say it to a judge and it goes swoosh, because there is, in a sense, I don't know, it sounds conspiratorial, but there's an agreement, if you will, in place that it's okay to treat women differently and worse, even though under regulations, even though a statute forbids it, because the Constitution allows laws to be interpreted as permitting second-class treatment. If the Constitution didn't permit it, the courts couldn't do it, even though the statute itself forbids it. I hope that's clear,
Yeah. Do you want to say anything about state constitutions? So
well,
would
state constitutions, so this is kind of a very complicated area of the law, but in many states, I think the number is 10. In about 10 states in this country, Massachusetts is one of them, the state constitution does give women equal treatment, subject to the highest degree of strict scrutiny. In other words, women are actually fully equal under the state constitution. So you would think that in a state like Massachusetts, and I can tell you a list of, I have a list of all the states that this applies to, if you're interested. Michigan, by the way, is not one of those states. Michigan has women in the Constitution, but it's subject to less than strict scrutiny. So you have, you
so
have.
Mary Pollock has put in the chat, Michigan has a constitutional amendment prohibiting sex discrimination or preference in public education.
Yeah, but it's
passed in
subject to
2006. Yeah, go ahead, Wendy.
Well, just the Michigan state constitution, although it guarantees women equality, it is construed that protection to be subject to less than strict scrutiny, which is equal to the federal constitution, again, less than strict scrutiny, which is a complicated constitutional way of saying you don't really have full equality. So in states where you do have full equality for women, it should be illegal to treat Title IX as a law that allows second-class treatment. But every time I make that argument, again, the judges, they just ignore me. They don't answer my question. They don't even consider or analyze what I'm saying because they know I'm correct. So they just ignore it. That's what's been happening in my cases. Some academics will say, well, federal law is different and a state has to obey the federal law, even if the federal law allows second-class treatment and the state wouldn't because it's a federal law, not a state law. But that's like a preemption argument. Again, not to get too complicated, but that doesn't apply. Preemption really doesn't apply here. Equal treatment of an entire class of people, if mandated by the state constitution, it has to happen, especially in a context like education. You can't rely on the second-class treatment under a federal law to justify weakening constitutional rights under state law. You can't. It's absolutely illegal. And that's why judges ignore me when I make the argument. They know I'm right. So just pretend she didn't say it.
Wow. Okay. So Kathy highlights the documentary, The Hunting Ground, which I find to be good. And also the book, Missoula, by John Krakauer, I believe. But Wendy, you find that book problematic, am I correct?
I published a law review article about Krakauer's book called Where Verisimilitude Meets, I forget. I mean, I'd be glad to send you a copy of it, but
give us a one-sentence synopsis if you can about the problems with the book.
That book is crap because, and I think Krakauer was probably paid by some of these anti-Title IX dollars because it was propped up and it was packaged and it was promoted as a really good book for women and expose of what was going on in Montana at this one school in particular. And if you read it superficially, you do get the feeling that, oh, he cares about victims. No. Everything he did in that book, and I am very excited to share my article with you because it's an important expose of how something seemingly good, when you really read it, is dangerously subversive. Oh, that's what it's called, Where Verisimilitude Meets Subversion, something like that. Anyway, no, the language he uses and the way he writes totally ignores the concept of equality, totally undermines the idea of Title IX as a civil rights law. And what he complains about is so superficial that it actually reifies the idea of Title IX as a second-class civil rights law while claiming that it's important. And there's so much wrong with that book, it makes me crazy. I also don't like The Hunting Ground, and here's why. They begged me to be in that movie repeatedly, over and over and over and over. And I said, I will be in this after you tell me who's funding you.
Oh,
yeah,
shoot.
Because
Who is it?
They wouldn't tell me. Tell me. And I was very concerned because the movie was being made at a time when it was, in my opinion, going to be used to propagandize support for the Campus Save Act, which is that federal law that was pushed through Congress really fast to overturn the Dear Colleague letter in 2011. That's the law Bunny and I sued over,
right?
Campus Save Act. So that film was being quickly put together to be used, and it was used as propaganda to support the Campus Save Act. And I said, I'm not going to let you, because they would have used me to legitimize the Save Act, and I was not going to be used. And because they wouldn't tell me who was funding them, I refused to be in it. And so I've been super critical of the piece, not because of its substance, but because of why it was done. And it was used to promote the Save Act, which was designed to overturn the Dear Colleague letter.
Wow. Okay. This is fascinating. And I've been telling Wendy she's got to write her autobiography, and I will assist you in that endeavor. Do you want to say anything? We got like 15 minutes. I want to get to questions. Do you want to say anything about this slide here?
No, I already mentioned this. Yeah.
All right, great. What about this one?
Already covered it.
And again, we are going to share the slides with you, audience. How about these states?
Yeah, so this is a really good example of what I was trying to explain: who has strict scrutiny, who has intermediate scrutiny. I don't know why Michigan isn't here. This could be an old slide where I might not have had Michigan done.
And you know what? I'm going to share the podcast, which talks about the legal concept of strict scrutiny, Ruth Bader Ginsburg, and the ERA, and why Ruth Bader Ginsburg is problematic.
Oh, she's really problematic. She actually did things to undermine the ERA, and people, keep your minds open, please, because
yeah,
I'm naturally suspicious of anyone who gets propped up, and I'm not a real lemming. You know, I'm a little more suspicious than most because of the nature of my work. But please, if you want to read about what Ruth Bader Ginsburg did, and if you're open to the idea that she actually hurt the ERA, I would be delighted to share my piece. It's in peer review now, so I'm not sharing it too much, but I just want you to please keep an open mind about the possibility that she was actually very harmful to the ERA.
It's a fascinating piece. And there's some women's groups who purport to be feminist also did their work to undermine it as well, which is very troubling.
Yeah, the National Organization for Women was established in the mid-60s. This is really an interesting little tidbit. The National Organization for Women was established in the mid-60s, supposedly because they were going to help with the ERA. Alice Paul had been an incredible force in this country to get both suffrage, and then she went immediately to the ERA. And when NOW was established, she joined, she was excited, she said, and of course she had already established the National Women's Party, which, by the way, sometime we got to talk about who abolished the National Women's Party and why, because that was an incredibly important, politically speaking, a really important entity for us. And Alice felt very strongly about the importance of women being together in a nonpartisan way in their own party. But the point is, NOW came along, Alice joined, she thought this was great. This was like a new source of force for her fight for the ERA as we moved toward congressional efforts in the early 70s. And so she went to their first national meeting, and she almost fainted when, I forget who it was, Betty Friedan was the president at the time. Betty said from the pulpit, the National Organization for Women is so proud to be here, and we're so glad to see all of you, and we want you to know we do not support the ERA. Alice Paul was like, what? So thankfully, Alice had enough cachet at the time. She stood up and explained why the ERA was important, and they continued to support the ERA despite Friedan's claim. But then Friedan had people go out into the states and even went to Congress arguing against the ERA, which it had some effect. But there's more to the story. But let's just say, to know that NOW emerged at such a crucial time for the ERA and then worked against it. They then did a lot of things seemingly in support of it, but not until later in the 70s when it was clear the ERA would fail. That's when NOW actually started fighting for the ERA, when it was clear it would fail before the deadline expired.
Wow.
Yeah.
Okay.
Yeah.
All right. The recent executive order from the Biden administration extends Title IX to LGBTQ plus individuals. What about the Equality Act? Do you want to say anything about that?
Yeah, this is a complicated area, and I have very strong feelings about this, but as you all know, there has been a growing divide, if you will, between gender and sex. Most feminists are concerned about the conflation of sex and gender because the erasure of women through the propping up of gender as a substitute is it's consistent with the same sorts of things we've been seeing, which is, if you make sex as a category less concrete, less clear, if it becomes murky, then two really important things happen. One, politically, women have less of a capacity to act as a united force, right? Because we don't have clear definitions of who we are and what we are united about. The nature of our oppression based on sex is a thing. If we erase sex and conflate it with gender, it becomes less clear of a thing. The second and far more important issue for me as a legal academic is that if we collapse sex and gender, we make sex mutable. Why does this matter? Because under the 14th Amendment's equal protection jurisprudence, only classes of people who have immutable characteristics are protected at the highest levels of legal standards. We get gold standard protection if the characteristics that attend to your suffering, the discrimination you endure, are considered immutable. You can't change them. They come with your body, right? So to focus and not just focus, but to make sex and gender kind of the same, and then recognize sex as mutable, you have just delivered to the Supreme Court the perfect excuse for them to continue to treat women as second-class citizens, even if the ERA passes. Think about that. That's the most
terrifying.
So I support all aspects of transgender equality. My doctor is transgender. I have transgender people in my family. I wrote an amicus brief in support of the transgender community in the Bostock case. I think absolutely everybody should be equal. I'm a amazingly intensely, maybe too intensely egalitarian when it comes to basic human rights. What I don't support is the erasure of women. I do not support the erasure of sex. I support everybody's status as subject to the best legal protections possible, and to make sex mutable is to declare that women will never be entitled to that full equal protection standard that other classes of people are entitled to. Right now, women are the only ones who, under the Constitution, cannot have full equality, right? We're the only ones who were excluded back in 1868 when the 14th Amendment was adopted, and we remain the only class of people explicitly denied full equality. So the solution to me is to unite as different classes of people in the demand that all people receive those gold standard full equality standards from the Supreme Court. That's not what's happening right now. There's instead this kind of really unfortunate and uncomfortable move to justify the second class treatment of sex by making it mutable. And I got a problem with that.
Right, I agree. So being mindful of the time, we have just 7 minutes. So let's just breeze through these. This is a very important slide. What can we do? Use courts and state oversight agencies when possible, frame sex-based harm as harm based on another protected class category. Always report to external authorities, such as 911. Many states have laws that treat police reports of campus sexual assault as confidential. Report sex-based incidents on campus under state civil rights laws rather than federal civil rights laws.
Yeah. Yeah.
We have more. Always use a restraining order in court. Gain truthful data on campus by conducting surveys, as Wendy mentioned previously. Report every offense in writing to all relevant school officials, including the president and board of trustees.
Yeah.
Okay. And a couple of tricks. And we gotta be really brief on this one. To use the Clery Act when it helps. Focus on impartial investigation mandate.
Yep. Yeah. I mean, these are things that are, so I'm saying rather than buying into what we're being told now are the new regulations and, kind of playing defense and saying, oh, I think I can prove unwelcome and severe and pervasive. Just ignore that stuff and focus on other things that people aren't really putting a lot of energy into, like the idea that impartial investigations are still required. What does an impartial investigation look like? Let's demand it. Let's try to build, a doctrine around the meaning of impartial, because that's important. Clery Act, as some of you know, is a law that requires schools to publish annual report cards on criminal incidents on campus. They have their own regulations that are procedurally speaking helpful in certain circumstances. You have to be careful not to frame your suffering as a crime, because that gives the school the ability not to treat it as a civil rights offense. So be careful when you use Clery. You can say, I'm demanding that you treat this as a civil rights offense, but I'm also saying that this aspect of Clery should help me in my procedural demands for justice or whatever. Framing is everything. And the Clery Act has nice aspects, but it's not a civil rights law. The Clery Act is not a civil rights law. So we have to be really careful not to use a law that is helpful in a way that causes us to then be accused of claiming that we're not seeking civil rights redress. Yeah, we want to be careful about that.
Okay. And we don't have much time. Here's our publications. Again, we'll share these slides. I am going to unshare my screen so that I can put some things in the chat for you. What I'm going to put in the chat is the 2011 Dear Colleague letter that Wendy mentioned. It's been rescinded. You should read it. And also the podcast, there's 2 episodes where Wendy and I discuss the ERA and the problematic legacy of Ruth Bader Ginsburg that people don't know about. So, and we'd love to have your questions if you have any right now. I want to hear about DeVos, Wendy, and the suit that you filed against her.
Yeah, so when Betsy DeVos came into power, the first thing she did was rescind the Dear Colleague letter and rescind some guidance from 2014, which was helpful. I won't go into why. And then she issued sub-regulatory guidance document. This was in September of 2017, a sub-regulatory guidance document that basically was exactly the same as what we now have as 2020 regulations. So she issued as a sub-regulatory guidance document, because you can do that as an agency without, you can just do it, right? You just issue, this is what I think the guidance ought to be. And you can only issue regulations after they are sent out to the public, and the public has an opportunity to comment, and it's a time-consuming process. But meanwhile, she issued sub-regulatory guidance. And I sued her. She did it in September, and I sued her in October. And all I said was, you can't issue guidance documents that allow schools to treat and mandate that schools treat women as second-class citizens under Title IX, when Title IX requires equal treatment. You can't do this, it's illegal. So my lawsuit was filed in federal court in Massachusetts, and I knew what was going to happen. Exactly what I knew was going to happen happened. They delayed my lawsuit until the 2020 regulations came out. So the court never had to rule on my case. That was very predictable. Run out the clock, if you will. And meanwhile, I said, well, okay, so now that the regulations, when regulations came out, they were a substitute for the sub-regulatory guidance. So the guidance disappeared, the regulations become the law. And I said, I'm going to sue, now I'll sue her about the regulations, right? And I was ready to file a lawsuit. I couldn't file until my case was dismissed, but I said, now I'm going to file a lawsuit about the regulations. But by the time that happened, several lawsuits had been filed by other organizations in a number of jurisdictions, including Massachusetts, New York, DC, I forget the 4th place. And they were filed by seemingly supportive organizations. And in many respects, the cases were all over the place. Some of them were better pled than others, but the bottom line is all of those lawsuits ended with the courts upholding the regulations, which is outrageous. So why did the courts uphold the regulations despite how obvious it is that they are illegal? And the answer is because they can. Because they can. Because women don't have equality in the Constitution.
So
It's
Wendy,
Mhm.
sorry to interrupt. We have 1 minute. Let's wrap this up in a neat bow. So how can we alleviate women being second-class citizens under the Constitution? The ERA, right? And so it has been ratified by, what is the number?
3/4 of the states. Yep.
3/4 of the states. Thank you.
Yep.
And who is the individual that is holding up this
Yeah, the
process?
archivist. So
Thank you. Yes, tell
Yeah.
the story, please.
yes, and also, Jesus, so much to talk about.
Listen to our podcast and you'll get the whole backstory, but there's one person holding up the ERA right now.
Yeah, and it's partly just Joe Biden. Just so you know, when the ERA was passed, it was sent to the states for ratification. That we didn't make it to 3/4 of the states by the time the deadline expired. So we kind of gave up. But then something funny happened in 1992. So the deadline expired in 82. Something funny happened in 92. Another amendment was adopted called the 27th Amendment, which pertains to congressional pay raises. And that amendment got 203 years to ratify. So women were pissed off. We're like, you can't give them 203 years and we only got 10. So we decided to fight to get those other 3 states. We made it to 35, we needed 38. We decided to fight back and get those other 3 states. And we figured we'd just file a lawsuit and figure out, whether we could claim that the 27th justifies our amendment. And we finally got to 38 states by January 2020. Virginia became the last state to ratify. Well, the archivist, who's like the librarian for the country, it's his job to publish new amendments when they become ratified. He told us in a letter in 2012 he would publish the ERA if we got 3 more states, even though the deadline expired. He was going to publish it. He told us that in writing. So that's why we spent so much energy getting those other 3 states. Well, when Virginia ratified in January 2020, he didn't publish. He refused. That was under the Trump administration. And then I sued him. Saying, you have to publish. You don't have any discretion not to. You're a damn librarian. You don't get to decide whether an amendment is valid. So I sued him. Then another lawsuit was filed after mine in DC federal court by the states that ratified over the past few years. And they said, you have to respect our votes. The ERA is valid. We both made the same arguments. I sued on behalf of women as a class. That DC lawsuit was on behalf of the states that ratified in the recent past. While both lawsuits were pending, we had the presidential election and women were encouraged to vote for Biden because Biden said he supported the ERA, as did Kamala Harris. So we voted for Biden. I voted for Biden thinking that's the solution to this problem. We just got to get Biden in and the archivist will publish because this was all about Trump. Well, guess what happened? We got Biden in. He did nothing. He did not tell the archivist to publish. He continued to fight against me in my lawsuit, arguing against the ERA. He did nothing to help the ERA, period.
So
He did
AAUW,
exactly the same thing Trump did.
Yep, AAUW, you have your new advocacy project right now. Start writing letters, file case, Mary Pollock, against this archivist. And
He's about to retire in April, and then we're going to get a new one, who will do nothing. So no, I think we're doomed. We're in a bad situation right now on the ERA because both parties openly oppose it. Both parties fought against us in federal court.
And nobody knows the story. People aren't talking about this.
We need a new women's party to be fiercely independent of both parties. And even if we never get enough money to fight for the ERA, we can use our vote. We will say to both parties, you don't get this ERA in the Constitution, we will vote for Alice Paul. I voted for Alice Paul recently on purpose. She's dead, but I'm trying to make the point. We will not vote for anybody until they do the right thing.
So we have a closing question, and I have to go, but I'm gonna reiterate, Sally, later on today, I will share these slides with you and all the additional links. And Wendy, if you want to send me stuff, I can pass it to Sally, and I'll send you Wendy's contact information. We got a question, why doesn't Biden support the ERA? It's political, it's money. So the ERA passes, all the states all need to change all of their laws, policies, guidance, right? And if you want to know more about this, listen to the podcast. We talk for 90 minutes just about the ERA, the backstory, and the implications this would have for everybody if this and a whole education piece would need to happen. So anyway, we have to go. Thank you, AAUW,
Thank
for
you.
inviting us.
Well, thank you. Thank
yes.
you, Jennifer. You've been wonderful. Thank you so much. And everybody, and you could just put it from the chat, we could do it that way, but there you go. Okay. So Wendy, your presentation was wonderful. I assume you have to leave right now too. I know most of us.
No, I don't. I can stay.
Okay.
I'm happy to stay.
Oh,
Okay.
I need to go. So please, if you have questions for Wendy, stay on the call. And thank you, Wendy. I love you.
Love you.
Thank you. Thank you, Jennifer. Okay, go ahead, Wendy. Okay. Wendy, I don't know if you knew this, but we used that letter in our public policy group and did a thing from Oakland and Macomb counties and sent that thing out to all the school districts saying whether they were in compliance or not. And we'd be happy to share all this with them. And we didn't get a lot of, it was just, but we felt like we were doing something,
Yes. And you should be proud of yourself. Just asking someone to follow the law is not nothing. I mean, and it's also a way of exposing people who might be saying they support women's equality, but then when you ask them to do something and they don't, what's going on here? That's the revelation about Biden being opposed to the ERA. I was devastated. But, Alice Paul always knew that neither party supported the ERA. She always held both parties equally accountable on suffrage. She said, whoever's in power is my opponent. And she was very right.
Oh, she's right. Okay, do we have any more questions for Wendy? You can unmute yourselves, Yeah, Jean, there you go.
What is this about Biden's not supporting the ERA? Somebody said something about money. Can you explain a little bit?
Yeah, there's an enormous amount of money in women's inequality, and it comes in a variety of packages. One, you won't be surprised to know that if equal pay were actually required, companies would suffer profits, right? They would have to pay more than they're paying women now, and that to them is a loss in profits. That's one very simple observation. The other less visible reality of where the anti-ERA and anti-Title IX money comes from is from and let me ask you if you even know this, from probably two of the most profitable industries in the history of mankind. They don't lobby directly, and you'll know why when you guess them. But what two industries do you think benefit the most from women's inequality?
Insurance?
Yeah, that's a good one. But actually, insurance is allowed to discriminate, believe it or not, because they have these tables that show risk. And if risk happens to be based on sex, they're allowed to discriminate. So I don't think they're as worried, but they're certainly an industry with power. No, the two industries that are extremely profitable based on sex, being sex trafficking and porn.
Yeah.
They benefit enormously from women not having equality because of what it would mean legally for women to be able to challenge the harm effectively if we had full equality. And those are $1 trillion a year global industries. They don't lobby directly, they lobby through proxy groups like the ACLU. And I'm not saying, the ACLU, I think, openly accepts money from porn. They're not secretive about it, but they wouldn't say we're here because we want to support porn and sex trafficking. They call it free speech. They also lobby as tech. Tech, I think, is the big tech, as people call it, I think is like the third most powerful lobbying group in DC. But tech makes most of its money from porn, and porn and sex trafficking are the same, pool of people. And we can never fight that back with money. We'll never have that amount of money. That's why the only thing we have is unity and the power of the vote. But we're not united. We get divided all the time, sometimes by efforts that are fraudulent, like a group will get propped up and call itself a feminist organization. And then they'll argue against equality and say that that's feminist in nature. I know you've certainly seen that, but even, even some seemingly feminist groups are co-opted. It's not new. The idea that a group that seems to be supporting an idea might actually be taking money from the wrong people and arguing against you, or doing it, but it's wrapped in some certain benevolent language, right? It's complicated and it's sophisticated. The ways that women are divided are much more sophisticated now than they were 100 years ago.
Yeah, Karen?
Wendy, you've burst a lot of my bubbles this morning. So let's go ahead and burst that last one about RBG.
Oh, yeah.
That was really,
I'm so
makes me
sorry.
sad.
I know. I felt the same way. I knew people who didn't have a lot of confidence that she was as solid on ERA as she seemed to be. So, and I'd met her several times, not one-on-one, but in small enough groups where I was really inspired by her. And I felt like, I don't know. I totally get what you're saying. But here's why I bothered to write my paper primarily about the true history of our fight for equality and what role she played. It was that after I filed my lawsuit against the archivist in January of 2020, because he's mandated to publish amendments when the last state ratifies. He has no discretion not to. He's just a librarian. He's not allowed to analyze what he thinks about whether the ERA is valid. He's a ministerial actor. Just boom, something comes in, boom, you put it in. So when he declined to publish, the decision to sue him was easy for me. And it was an easy win, or it should have been an easy win, but it wasn't. Well, one of the reasons it wasn't is what RBG did. I think it was, so I filed in early January of 2020. I want to say it was March of 2020 that RBG went to Georgetown Law School and gave a speech. She gave a talk like she always does. She would routinely go and give Q&A sessions to local law schools. So it wasn't a surprise that she did that. But when she got there, somebody asked her a question. It was obviously a setup question. Somebody asked her a question about the ERA in light of these two lawsuits that had been filed. By the time this happened, both of our lawsuits had been filed, mine in Massachusetts federal court, and then the one by the states in DC federal court. And she said, well, let me tell you what she should have said. What she should have said was, I don't want to talk about that because these cases are pending in federal court and they could end up before me and I'm not allowed to talk. It's unethical for me to tell you what I think. What she said was, the ERA is dead, women have to start over. And that got a lot of news. And of course it was used against me in my case, but I was so shocked that she said something unethical like that, because as I said, I had been in front of her before in a small audience, and she was asked other questions that were controversial or interesting, and she said, I can't answer that because it might come before me. And that was without even any cases pending. Now there are 2 cases pending in federal court, and she opines the ERA is dead, women have to start over. I was horrified, devastated, but I was also inspired. I said, I have to go take another closer look at her work because this bothers me. And that's what I did. I went and very carefully examined her work in the early 70s when she was winning all these cases that she gets celebrated for. And let's just say what I found out about what she did in those cases is what my paper's all about. And the short version is, because it's a little legally complicated, the short version is she had opportunities to advocate for and argue in favor of women's equality in those cases, and she didn't. And in fact, her cases helped to perpetuate that second-class standard that is where we are now. She has been celebrated for the very cases that I write undermined the ERA and weakened women's rights. That's
Yeah.
the short version.
Okay, Mary?
Yeah, I have followed some of your work over the years because I've been doing this kind of advocacy since I became aware of things when I was a college student in the 60s. There has been discussion about, is the current ERA as proposed, as that language, what is needed, or do we need different language? And of course, you know, there's been different language, start over. What is your take on what would be the best language? If we do have to start over, what would be the best language?
That's a really good question. Well, first, let me say that the reason the current language is what it is, the based on sex language, is because it was intended to reflect the language used in the 19th Amendment and the 15th Amendment. The 15th Amendment, some of you may know, is the amendment that gave Black men the right to vote.
Mhm.
So Alice Paul, when she rewrote the ERA, that was not the first iteration, but the 1943, I think, iteration is what it is now. And it has that based on sex language, and it was done to mirror existing constitutional amendments to prevent confusion, because we didn't want courts to say, well, you know, they use different language for the ERA than they used for the 15th and the 19th. To make it clear that we were trying to do the same thing, we used language that mirrored those amendments. Now, having said that, the first version of the ERA, which was written in 1923, used the language of women and men. And that was intentional, and some people would say was a better use of language because it was women alone who were excluded from the 14th Amendment. Now, what's interesting is, well, you might say, well, we didn't have these other categories of people back then, and they are also excluded. They just weren't recognized back then. But because we know that the intent to exclude women and only women was by design what happened with the 14th Amendment, we just wanted to fix the error that was intentional by sticking women in where women alone had been excluded. That's why that language was originally proposed in 1923. We've become a more complex society in terms of people having status as classes of people based on more categories than what we had back then. And those categories of people, for good reason, maybe say, I don't feel protected by the word sex. But here's the thing. In the Bostock case, which was just from a couple of years ago, the United States Supreme Court said the word sex from Title VII captures all ways of being, both gender and sex. It's just, they said the word sex is broad enough to cover everybody in terms of these categories, like, you know, sex and gender. So that made me very happy because I thought, wow, now we're going to get the LGBTQ community on board with the ERA, because there's no way the Supreme Court in the future is going to say, well, the word sex under Title VII covers all these categories, but not for ERA, because they were passed at the same time. You know, all the stuff, the use of the word sex was kind of used at the same time. So it would be impossible for them to say the word sex under ERA doesn't capture everybody. So I don't mind using the word sex for that reason. Where I mind using the word sex is the way that the courts have construed it to mean the only way you can prove sex discrimination is if you can show that women are treated differently than men. That binary comparative requirement is very ineffective at this point, because, for example, what happens when sex as a category is excluded from protection? And the perfect example of that is hate crime laws. In many jurisdictions, sex as a category is excluded. It's not that women as a category are excluded, it's sex as a category is excluded. So how am I ever going to prove that it's discriminatory not to cover women under a state's hate crime law when somebody's going to say to me, well, how does a law that doesn't cover sex exclude women? It equally discriminates against men and women, so I don't have a claim. And I don't like that. I still do have a claim in my view. You can discriminate against sex as a category, and in a sense discriminate against both men and women by excluding the category. But the way the doctrine has emerged over the years has required us to always pit men against women in the way that we think about whether discrimination against women has happened.
there have always been intersex people.
Yeah.
People born with indeterminate sex, with sex organs that look different than perhaps their genetic, if you tested their blood for genes. And throughout history, there have been intersex people, much less what we now call transsexuals, or old times transsexuals, now called transgender folks. And now we have surgeries and so forth. So there are more non-male, non-female categories. I guess that's what you're getting at. So the bottom line is, do you still like the current ERA language?
Well, the answer is yes, because for that purpose, sex, according to the Bostock decision, Supreme Court, sex captures everybody.
Yeah.
So I don't have a problem with
You're not
that.
happy with it. Yeah.
No. If the Bostock decision hadn't come down the way it did, and and you asked me that question, I'd say, I'm not sure. I don't know if sex covers everybody, but the court was clear that it does.
So we have an important decision awaiting our Michigan Supreme Court decision, and our Attorney General, Dana Nessel, who you might be familiar with, personally argued this case, and we're awaiting the decision. It's to define sex to include sexual orientation and gender identity in our state civil rights law. This decision could come out in the coming weeks. So that's something to watch for. I also put in the chat the link to our, what I would call the Ward Connerly anti-affirmative action ballot proposal in 2006, which was passed by Michigan voters. But it only is an equal protection and no preference, no discrimination in education, public education. Nobody has used it to substitute for Title IX kinds of arguments. And there are other states, California, Arizona, I think Colorado defeated it, but there are other states that may have this no discrimination in public education that was designed to be anti-affirmative action, but could be used, but people aren't using it.
Yep. And I say that, Mary,
protection clauses.
in one of my slides, I say, don't use Title IX if you have a state law that helps you, either constitutionally or a state civil rights law. Absolutely. And Massachusetts is a good example of that. We have such strong language in our state laws, but people still only talk about Title IX because it's like a knee-jerk reaction to frame everything as a Title IX law. I don't. Sometimes I have my students say, I am seeking redress under state law, and I do not want you to apply Title IX.
But I think there's an academic article here for you to look at these state anti-affirmative action ballot proposals that passed. If they're only affecting education.
Yeah.
And what has transpired in the last 10 to 15 years about these.
I do have to
I don't
say,
think they're being used as a substitute for Title IX.
No, and it's a propaganda, it's an information issue. It's who's representing these clients that why aren't they, if you're a lawyer, you're supposed to use your client's best argument, not the worst argument just because it's in the news all the time. Right. And so lawyers aren't being trained to think differently. Lawyers aren't being trained to be creative. I've been teaching for over 20 years at a law school. I teach sexual violence and law reform. All I do is teach my students how to not obey the law, how to think out, not think outside the box, how to kick the box in the ass. But that's not how most lawyers are trained. So it can be challenging. It can be challenging. And when judges see you file something that's not something they see all the time, they get nervous. Happens to you know, I
Okay.
file something and they'll say, Ms. Murphy, nobody else files this. And I say, well, that's not my problem.
That's right.
We have to do things like that. I just want to say, Mary, quickly about the trans/sex issue, because it's a vital piece of this debate. Sex can cover all categories. It should not be redefined. Sex is its own thing. Trans is its own thing. Intersex can be its own thing. Everybody gets equality, but you don't erase the nature of sex. That's how I feel. Not everybody agrees with me, but I'm saying, to me, because women need political unity as women, because women suffer as women, it doesn't mean that other people don't suffer as other things, but because women suffer as women, we need to be able to unite as women. And I don't like anybody touching the contours of the meaning of our class. We are a class of people who need to unite as a class of people. I say, you know, when people talk about identities being important, I say, yes, it's fine. It's fine. But, you know, what about people who are half Black, half white? And maybe they suffer discrimination because they identify as the color that they don't really reflect. There are white people who have been raised in Black culture and vice versa, and they identify as something other than what they look like. They also might suffer discrimination because they are more than one race, right? There is nothing going on to expand the definition of race to cover racial identity. Why is that? Why is this only happening to sex?
Dana Nissel and I actually worked on a ballot proposal to amend Michigan's Equal Protection Clause and this was thought through. Looking at some of the comments you just made, we wanted to add sex, sexual orientation, gender identity, 3 categories to the Equal Protection Clause, because we didn't want this confusion between all the laws that consider sex, male and female, with the laws that we wanted to bring in that would protect LGBT folks of all kinds and varieties. So, but we were not successful because, strangely enough, the gay community wanted they didn't want a constitutional amendment. They wanted a legislative proposal that they'd been working on for 10 years. So we backed off.
Okay, you know, I have to interrupt here to say that I have to leave. Okay, I have made Leah co-host if she wanted to continue it, and because I have another appointment that I have to get to, and tell you, Wendy, this has just been fantastic, and I'm sure these people could keep you here for a long time. So it's sort of up to you guys if you want to end now or not, because but I do have to leave. Leah, I don't
so much, Sally.
Yeah, and I actually need to leave momentarily too, because I have something I need to do before 1 o'clock.
Okay, so then I think that I suppose I could make Mary co-host. She knows how to Zoom. But what do you think? Okay, I think maybe it's been an hour and a half, and it has been
we can talk by email. We can have another event in the future.
I hope so.
I just love being with women. I love smart women, and I don't ever, you know, intend to go anywhere. I have a lot of, you know, just so much respect for people with open minds who care about these issues, and we just need to stick together and keep talking.
Okay, well, there will be a recording of this on the Michigan, AAUW Michigan webpage. And Leah takes care of that. Thank goodness we have people who know a lot more than I do. Okay, thank you again. And
Thanks,
Jerry,
everybody.
thank you. All right, thank you. It's been wonderful.
Thank you. Bye-bye.
Bye. Okay, all right, I have to end this. Okay, oh, first I want to end the recording. How do I do that? Pause, stop recording. Okay. There. Yes.